A presentation by the FW de Klerk Foundation. Over to you.
Thank you. Good morning, Honourable Chair and committee members. I am just confirming that everyone can see my slides.
Yes, we can.
Okay, fantastic. I am Daniela Ellebeck, an attorney and the Constitutional Programs Manager at the FW de Klerk Foundation. Joining me is my learned colleague, Mr. Ismail Yusuf, the Constitutional Programs Legal Officer. We have previously had the privilege of addressing this committee at the public hearings on this bill. Now, the Foundation is a non-profit organization dedicated to upholding South Africa's constitution. And our vision is to make our constitutional democracy a reality for all South Africans. To this end, the Foundation seeks to promote the Constitution and the values, rights, and principles it enshrines by, inter alia, monitoring developments including legislation and policy that have the potential to affect the Constitution or its values, rights, and principles. The Foundation does so in the interest of everyone in South Africa. We welcome the opportunity to make this concise oral submission to the committee, trusting it will be of assistance in guiding the committee in its deliberations regarding this bill, with its broad surveillance scope that risks eroding privacy, empowering state interference, stifling dissent, endangering democratic principles, and raising concerns about abuse. Now, the GILAB aims to amend 3 intelligence laws: the National Strategic Intelligence Act of 1994, the Intelligence Services Act of 2002, and the Intelligence Services Oversight Act of 1994. Now, the principal acts, as they would read, once they have been amended by the GILAB, as it currently stands in this version in front of the committee.
I don't see your slide rolling. You're still on the very same slide.
Yes, Chairperson, it is meant to be on that slide.
Okay.
There's no technical fault.
Oh, we've got the hard copies. You can continue.
Fantastic. Thank you, Alita, for distributing the hard copies as well. So the principal acts, Chairperson and Honourable Committee members, as they would read once they have been amended by the GILAB in its current version in front of this committee, were attached to the Foundation's written submission made to this committee as Annexure A. Now, the changes that the bill sought to introduce into each act were inserted and highlighted in yellow, and we trust that this would be a valuable resource to the committee members, allowing them to see the bill's cumulative effects if the changes were to be made to these laws. Now, the Foundation is concerned that the bill's proposed changes that it's asking Parliament to make will directly infringe upon various constitutional rights, including the rights to privacy, freedom of expression, political rights, freedom of occupation and trade, and access to courts and enforcement of rights, which I will just call access to justice. Now, as this Honourable Committee is aware, the state is bound constitutionally to not only uphold these rights, but also to respect, protect, and promote them. And should the state wish to limit any of these rights in the Bill of Rights, it may only do so in accordance with Section 36 of the Constitution. Now, turning to the Foundation's substantive concerns about the bill, these can be divided into 2 main categories. The first is the bill's problematic definitions, and the second is the fact that the bill makes it compulsory for the State Intelligence Agency to conduct vetting investigations on persons or institutions suspected of being threats or potential threats to national security. And these vetting investigations will be done to determine these people, institutions' security competence for purposes of obtaining a security clearance certificate. Now, turning to the first category, the problematic definitions. First and foremost, the term threat, a crucial concept underpinning the entire bill and various definitions, is undefined. And I pause to mention here that this crucial concept is also undefined in all the principal acts. Now, the Foundation's proposed definition for threat is found on the right-hand column of that table. The second is the definition of threat to national security, which is defined as including subversion and undue influence by hostile interests on government processes, policies, and the sovereignty of the state and its organs. However, because the bill fails to define either threat or to exclude and protect lawful activity, advocacy, protest, or dissent, as I paused to mention it does do elsewhere, the result is an overbroad definition that could potentially include citizens or institutions who oppose policies, regulations, draft laws such as this very bill that the government wishes to adopt. And as such, a threat to national security could include civil society. Turning to the definition for personal institution of national security interest, this definition is extremely concerning because it rests on two problematic concepts. The first is that these are people institutions whose activities are deemed by the intelligence agency to be inconsistent with Section 198 of the Constitution. However, any action that is seen as affecting South Africans' resolve to live as equals in peace and harmony, be free from fear and want, and to seek a better life is contrary to Section 198 of the Constitution. These vague concepts mean that anything could be seen as contrary to Section 198 of the Constitution, and therefore anyone who catches the agency's interest could be said to be a personal institution of national security interest. And the unintended consequences, honourable committee members, of such an overbroad definition could be that there is no sphere of the public realm, whether that be education institutions, private businesses, journalists and media, or civil society organizations and their employees, that will be safe from the agency's prying eyes. Now, the second problem is that these activities include, but are not limited to, activities that are defined as a threat to national security, which, going back to our previous slide, is problematic for the reasons we canvassed, namely the fact that this fails to exclude lawful political activity, advocacy, protest, or dissent. Turning to the definitions for national security and opportunity or potential threat, both of these are highly problematic because they are circular. And circular definitions are definitions that rely on themselves or other undefined terms within the same context, thereby creating an endless loop of interpretation. Now, I'm going to turn to the next slide, which I hope clearly shows why these definitions for national security and opportunity or potential opportunity are circular. First of all, we can see that in Clause 1M, the GILAB defines national security as, quote, the capabilities, measures, and activities of the state to pursue or advance any threat, any potential threat, any opportunity, any potential opportunity, or the security of the Republic and its people, in or outside the Republic in accordance with Section 198 of the Constitution, end quote. Turning to Clause 1O of the bill, which defines opportunity or potential opportunity, we see that it's defined as subject to the Bill of Rights and the principles enshrined of the Constitution, such capability, measures, or activity employed to pursue and advance national security in accordance with Section 198 of the Constitution. Now, honourable committee members, the result, if you plug these respective definitions into one another, is a circular definition that reads as follows. For national security, you get a definition that says the capabilities, measures, and activities of the state to pursue or advance any threat, any potential threat, national security, or the security of the Republic and its people. And for opportunity or potential opportunity, you get a definition that reads, such capability, measures, or activity employed to pursue or advance any threat, any potential threat, any opportunity, or any potential opportunity. So what we see is that an opportunity or potential opportunity is effectively defined as any opportunity or any potential opportunity that the state pursues. Now, first, this definition is unworkable because it's open to abuse due to its circularity. The second is that the concept of potential threat or potential opportunity is redundant, as I would submit to the Honourable Committee that both threat and opportunity are concepts by their very definition, which are potential danger and a potential good, respectively. Third, the intelligence agency seems to have carte blanche in deciding what will be deemed as either a threat or an opportunity, as the bill fails to provide any factors, in other words, any parameters, to be considered in the identification of either of these. National security is similarly defined as the pursuit or advancement of national security. Now, not only is this unworkable and open to abuse due to its circularity, but it's arbitrary and thus irrational, and because of this, it fails to comply with the Republic's founding value found in Section 1C of the Constitution, namely the rule of law, making it unconstitutional. Turning to the definitions of domestic intelligence, foreign intelligence, intelligence gathering, and national security intelligence, all of these include and rely on the concepts of threat or opportunity, or potential opportunity or potential threat to national security. Now, due to the problems with these concepts, as already canvassed, these definitions are overbroad and unworkable and open to abuse. Turning to the definition for security competency test. Now, the bill currently reads as follows. Security competency test means administering a vetting investigation to determine the security competence of a person or institution, and if such a person or institution is suitable to access classified information or critical infrastructure of the state, or is viewed as vulnerable to blackmail, undue influence, or manipulation, or security compromise, or is a person or institution of national security interest in terms of Section 428I of the Act. Now, this disjunctive reading, in other words, the use of or as opposed to and of the various factors, makes the definition of security competence test overbroad, because literally, honorable committee members, every citizen in the Republic can be deemed to be vulnerable to, for example, manipulation. But that does not mean that they are a threat to national security or that the state should be able to administer a security competency test on them. This disjunctive reading results in the clause failing to achieve its purpose, which is no doubt only to vet individuals with access to classified information and critical infrastructure of the state, not every single citizen in the Republic. And the clause's failure to achieve its purpose results in an arbitrary infringement of the various rights and a failure of the justification analysis contained in Section 36(1) of the Constitution. Turning to the second category of the Foundation's problems with the bills, the compulsory vetting. Now, as can be seen from these slides, the bill makes it compulsory for the agency to conduct vetting investigations to determine the security competence of a person or institution suspected of being threats or potential threats to national security for the purposes of issuing a security clearance certificate. Now, the result is that due to the wide definitions of threat to national security and national security, these clauses would allow for civil society organizations and those working for them to be seen by the intelligence agency as persons or institutions of national security interest and to be subjected to a vetting investigation to determine their security competence. In other words, should they be granted a security clearance certificate or not? Now, should a person or institution of national security interest, in other words, an external person who does not have access to classified information and is not capable of espionage, be seen as acting inconsistent with Section 198 of the Constitution or as a threat to national security, they would fail to get a security clearance certificate. The implied risk of failing to obtain such a certificate is that if you're an organization, you would no longer be able to continue operation. And possibly, if you're a natural person, you may even face criminal prosecution as a terrorist. Now, turning to one last problem that I just wish to highlight briefly, and I'm sure many of the other stakeholders will go into this in depth, so I'm just going to name this briefly and flag it for the committee, is the bill's failure to comply with constitutional court judgments. Now, the committee is no doubt aware of the matter of Amar Bugani Center for Investigative Journalism and another versus the Minister of Justice and Correctional Services, which was a matter in which judgment was handed down in 2021. Now, in this matter, the Concord held that RICA, the Regulation of Interception of Communications and Provisions of Communication-Related Activities Act of 2002, was unconstitutional because it failed to provide for post-surveillance notification to the people who had been subject of the surveillance. And the court said that this failure amounted to an unjustifiable infringement of their constitutional rights to privacy and access to justice. Now, the bill contains the same failure and is therefore prima facie unconstitutional. Now, in summary, the bill will result in the state being able to spy on anyone it sees to be a threat to national security without ever having to tell the people spied upon that it had done so. A threat to national security because of the problematic definitions would include civil society, activists, religious organizations, media, journalists, and even private businesses. All of this makes the bill open to abuse by any future government wishing to threaten or even silence critical voices opposed to it. Should the state wish to limit constitutional rights, it may only do so in accordance with Section 36 of the Constitution, which amongst others requires consideration of the nature and extent of the limitation, the relationship with the limitation and its purpose. And given the fact that, for example, many of the clauses fail to achieve their purpose, this bill would fail to meet the Section 36(1) justification analysis. Also, by failing to define the parameters of what is used to determine if someone is a threat, and by including vague and overbroad definitions which are open to abuse, the bill fails to pass the Section 36 limitation test. Due to the circularity of many definitions, it also fails to comply with the rule of law, which is a founding value of the Constitution. Thank you for your time and your consideration.